So I was asked to talk about the First Amendment cases, and there are four of them. One religion, which turns out to be a statutory but First Amendment adjacent case, and three free speech ones. I will say you were promised blockbusters. I can't say these are blockbusters. They're interesting enough, though, on their own terms. I hope you find them so. So let me start with the religion case. So from about 1963 to 1990, the Supreme Court took the view that when people had religious objections to generally applicable rules, they were presumptively entitled to an exemption. Not always. The government could show that denying the exemption was really necessary to serve a compelling government interest, but generally speaking so. There's one famous case, for example, in which the Amish got an exemption from a requirement that their children be educated past age 14, because they said that our religion and our religious lifestyle requires them to not go to school at all, not go to public school, not go to private school, because they'll be working with us on the farms. And the Supreme Court in 1972 said, yes, they get an exemption. This was, for quite a while, seen as a very liberal perspective, and the objectors were generally conservatives. Justice Brennan was a major architect. Justice Brennan and Marshall were strong supporters of this. Chief Justice Rehnquist, and before that Associate Justice Rehnquist, was quite sharply against it. And in 1990, the Supreme Court, in a basically 5-4 decision, with the majority being mostly conservatives and the dissent mostly liberals, overturned that rule. And what it said is, free exercise clause means that the government can't target people or practices for discrimination because of religion, but it doesn't have to give religious exemptions either. Legislature could, if it wanted to, like historically it had done with draft exemptions and the like, but it had no constitutional obligation to do so. That was the famous Employment Division versus Smith case. And it led to, and again, the politics of religious exemptions, very different back then, led to a massive opposition and a coalition, which was basically led to unanimous vote in House of Representatives and near unanimous vote in the Senate in favor of enacting as a statutory measure what the court had dislodged as a constitutional measure, entitling people to an exemption from these generally applicable laws as a matter of federal statute. Supreme Court then later held that that couldn't be applied to states, but then a few years later, in 2000, around 2000, the Supreme Court enacted the so-called Religious Land Use and Institutionalized Persons Act, which is pronounced RLUIPA, spelled R-L-U-I-P-A. If you ever hear about RLUIPA, that's RLUIPA. I don't know of anybody who's named their daughter RLUIPA, but you could imagine that, and her sister Rifra. So RLUIPA provided that anybody who, among other things, this is the Institutionalized Persons Act, anybody who was an inmate in a prison or jail that was getting federal funds, including state jails and prisons, would be, again, presumptively entitled to these exemptions. So that was the statute that was at issue in a case called Holt v. Hobbs, in which a Muslim inmate sought an exemption from an Arkansas grooming policy that barred the wearing of any facial hair. This is a generally applicable, facially neutral policy. It wasn't aimed by anybody's account at Muslims or Sikhs or Orthodox Jews, the beard-wearing religions, but it did indeed substantially burden the Muslim who felt a religious obligation, as I believe not all Muslims do, but many Muslims do, to wear a beard. And the Supreme Court unanimously, in an opinion written by Justice Alito, held that in fact there was an exemption available. And this is interesting because this is in a prison context. The court is usually quite deferential to prisons. And even under our LUPA, the court said there had to be some degree of deference to prison judgment, among other things because of security concerns. But the court concluded that that deference ultimately didn't get the prison far enough. The prison, for example, argued, there are some other arguments, but I'll mention one in particular, argued safety. That we need to have grooming standards because otherwise people can keep contraband in their facial hair. But Holt, the claimant said, I don't want to grow a long beard. Maybe that would be my preference, but I'm willing to compromise. I just want a half-inch beard. How much am I going to be able to fit in a half-inch? What's more, there wasn't a bald head requirement. You could have head hair. So it seems that the prison, was fine with a risk of contraband and considerably longer hair potentially. You had mechanisms for trying to sort through that and prevent that. What would be the problem with beards? And the court went along with that. And that was an interesting example of how well religious exemption claims have been faring under these federal statutes, RFRA and ARLUPA. This is the third claim in 10 years that had been accepted by the court. Obviously, the Hobby Lobby case involved such a claim where the court split basically 5-4. But this case was unanimous, as was an earlier case, O Centro, which was 8-0 back in 2006, which involved an exemption from drug law, of all things, not the sort of thing easiest to get exemptions for a particular kind of hallucinogen that was used by a Brazilian religion that had been adopted by some Americans. Interestingly, back in the era where it was supposedly constitutional compulsion to carve out these exemptions, presumptively. So the court often found the presumption rebutted. Most of these exemption claims that came before the court were rejected. Most kinds of such claims were rejected. And likewise in lower courts, they were very largely rejected. But now that in a sense the standard seems less mighty because it's not constitutional but statutory, the court is actually enforcing it more powerfully, perhaps in part because it's no longer a question of the court using the Constitution to trump the judgment, to overcome the judgment of the elected branches. Rather, it's using a statute, itself the voice of Congress, to overcome the judgment of democratically elected branches. So the rhetoric is not, well, what was done was unconstitutional, and we are going to stop it. We're going to stop Congress or a state legislature from doing that. Rather, we're going to enforce the will of Congress. Congress has told us to do this. We're going to go ahead and do this. This is important partly because while this is an ARLUPA case, a lot of the same logic will apply to federal RFRA claims with regard to federal statutes, like in Hobby Lobby, and to state RFRA claims. 20 states now have similar state statutes. Maybe about a dozen states have state constitutional provisions that have been read to follow that. So a lot of the religious exemption litigation is going to get a boost from cases like Holt v. Hobbs. So that's religion. Now let me turn to free speech. Here there was no unanimity in the free speech cases except as to the result, but not the logic of one of them. Also, interestingly here, there were three major free speech cases, and it was the first term that I recall, I believe that has ever happened, where in all three of them, the majority of the conservatives took a more speech protective view, and the majority of the liberals took a less speech protective view. That isn't always so. A lot depends on the particular kind of case. But in this particular term, possibly because of that accident of which cases were selected, it was 3-0 in that direction. One of the cases, let me start with, is Walker v. Texas Division, Sons of Confederate Veterans. So Texas, like many other states, decided to raise money by allowing groups to essentially pay for designs for license plates. This is a program that's open to a vast range of groups. In Texas's case, there were many dozens of license plates allowed. And if you pay some amount of money, you essentially assuring that some number of people will buy the plate, you get this plate. So it's sort of seen as win-win-win. The state wins, the group wins because it makes some of the money, the state wins because it gets money, the group gets some cut of the money, and the drivers get to display their affiliation with some particular group. What kinds of groups? Well, University of Texas, most certainly. Louisiana State University. That's very open-minded on the part of Texas. Remax Real Estate, Mighty Fine Burgers, Choose Life license plate, so political messages, a wide range of messages, some of which might be in agreement, the majority of the Texas legislature might be in principle in agreement with, some of which it might not be in agreement, most of which it doesn't really care much about. It's just a program that was set up that basically any group could join. But what happens, the Sons of the Confederate Veterans wanted to join, and they wanted to put up the Confederate battle flag, or at least, I suppose, a Confederate battle flag. Apparently there were several. And the question was whether the state could say no. But the question in this case was Confederate veterans, but in other cases, the state tried to say no to other things. In some cases, it tried to say no to pro-life, anti-abortion plates. In other cases, it tried to say no to pro-abortion rights plates. So it's pretty clear that this wasn't just a Confederate flag issue. This was an issue that came up in a lot of different contexts. And the Supreme Court, in a 5-4 vote, which is basically the liberals plus Justice Thomas against the rest of the conservatives, said that the state gets to choose. The state gets to say no, no Confederate flag plates. Why? Because this is government speech. If this were treated even as a government-owned program, but a non-public forum, the state would have to be viewpoint neutral. For example, if the state sells advertising on city buses, excuse me, the city sells advertising on city buses, has to be viewpoint neutral in the program. It can't say no pro-Confederate ads or no pro-life ads or no pro-choice ads or whatever else. But if the state wants on its own, in its own programs of speaking, if it wants to, let's say, on signs that it itself puts up, say certain things but not other things, it's free to do that because, like any other speaker, it gets to choose which viewpoints it wants to promote. The question is how you classify this forum, and the court said, well, this is a government speech program. The dissent said, Justice Alito in the dissent said, look, really, people are going to be seeing these cars drive by and say, ooh, Texas endorsing LSU. Texas is all over Mighty Fine Burgers. Texas is super into young lawyers. That was another license plate. No, people would recognize that this is private speech, happens to be on government property, as very many kinds of private speech, again, remember these bus ads are, but the majority disagreed. This is a case that has a very little practical import on its own terms, simply because right next to that license plate, you've got your bumper. And if you want to, you can put any message you want on your bumper, cheaper and more legible and more conveniently, with more choice than on your license plate. The interesting question is what further implications all may be. Let me flag one of them right now. There's currently, as you may know, litigation about whether the Redskins trademark the government could cancel on the grounds that there's a statutory provision that bars the registration of certain kinds of offensive marks. So the question is whether the government could cancel that. Interestingly, it's not coming up primarily in the Redskins case. It's coming up in a different case called In Re Fan, which involves an Asian American band which calls itself the Slants. And the Trademark Bureau said, no, you can't have that because we think that's a racial pejorative. And the band says, well, we want to have it. And the question that the Federal Circuit, which is the court in charge of trademark appeals, is facing right now, among other things, is whether the trademark system is seen as a matter of government speech or as a matter of private speech that the government facilitates, because that will affect whether it's permissible to exclude things based on viewpoint. I should mention, by the way, in the trademark context, it's clear the Redskins would in any event be free to use that name. The question is whether it would have certain exclusive rights in that name, and that is what the Sons of Confederate Veterans case might affect. There are two other free speech cases. One called Williams-Yulee v. State Bar involved judicial elections. In most states, unlike the federal system, there are judicial elections. You can like them, you cannot, they're there. And if you're going to have elections, any meaningful elections, you're going to have campaigns. If you're going to have campaigns, you're going to have money. So how do these election campaigns run? Well, they also have campaign contribution limits like political campaigns have, but in Florida there was another provision, which is that a judge cannot herself specifically solicit money. But not just can't solicit money in person, can't send out letters over her own name, can't put up solicitations on her website, signed with her own name saying, please contribute money to me. And the Florida Bar said, and the majority of the court, the four liberals, in this instance Chief Justice Roberts, said, well, there's a compelling government interest in restricting this kind of speech, and that interest is in maintaining a perception that judges can't be bought through contributions. So here's the problem, as the dissent pointed out, though, the judges could have a campaign committee that sends out these letters. And it's not clear that somebody would feel any more of a sense of being imposed on if the letter goes out over the name of I forget her first name, Linda, I think. In any case, Williams-Yulee, or the committee to elect Williams-Yulee. Maybe if the restriction was aimed at face-to-face requests, where it may be hard to say no to somebody who you know might be the judge in front of whom you'll be practicing in a year, maybe that would have been a different story. But here there's a prohibition even on websites where it's hard to see again how that would create pressure on someone that's any different if the website is signed by William Zuley or by the committee. So again, a case over not very much also, because it's not like William Zuley, she lost this election, but the next election will be that much burdened by it. She could just have her campaign committee do the solicitations for the very same reason that it's hard to see how this restriction does much good. It's hard to see how it restricts speech very much. But the principle that it's okay to restrict speech in this content-based way is something that might have substantial carryover in the future. Probably not in traditional campaign finance cases, because there's already a huge body of case law dealing with those, but in other kinds of cases where the so-called strict scrutiny compelling interest test is invoked. Let me close with one last case, which is also about content-based restrictions, which went the other way. And this one, the opinion was written by Justice Thomas for the 5 conservatives plus Justice Sotomayor. And there was a separate concurrence by Justices Kagan, Breyer, and Ginsburg. So here's what happened. This is Reed v. Town of Gilbert coming out of Arizona. Town of Gilbert had sign restrictions, as many cities do, because they don't want to have all these signs everywhere, because the concern being that the signs are ugly and the signs are distracting to drivers. So what do the city say? It says, well, if you have ideological signs, you can have a sign up to 20 square feet. And you can have it up for however long. If you have political signs about elections, you can have a sign up to 32 square feet. But you can only have it up for 60 days before an election, I think 15 days after. But if you have event signs, which are signs about your upcoming events, they can only be 6 square feet, and they have to be put up at most 24 hours before the event. So Clyde Reed, who was a minister who had church services that, because his church was a small church, they were in different places at different times, wanted to put up signs for the services, but was told, okay, you can only do these brief, temporary, small signs. And he says, well, look at all these other signs that are allowed. Well, those are allowed because they're political or ideological. And the Supreme Court said, by a 6-3 vote, these kinds of content-based restrictions are presumptively unconstitutional. And it takes a lot. William Zuley said in that case that there was a lot, but it does take a lot to uphold these restrictions, and a very, very great deal. Counting William Zuley, there have only been 2 cases in which the Supreme Court majority opinions have upheld content-based speech restrictions under the strict scrutiny test. The concurrences, the concurring justices agreed that this restriction was very hard to justify, the difference in treatment between these kinds of things. But they said, look at all these other content-based restrictions. For example, there are rules that say you can't have signs, but it's okay to have signs indicating historical landmarks. What's wrong with that? Why don't we look at the motivation of the legislature? And the motivation of the legislature is to try to play favorites among ideas, or even to try to restrict subject matters of speech where there may be some kind of indirect discrimination based on viewpoint, then in that case that's impermissible. But if the motivation is simply the laudable one of helping people get around and see the historical landmarks, while at the same time not having this huge amount of signs that will create ugly visual clutter and that will create traffic problems. What's wrong with that? And the majority said, well, what's wrong with that is that it is content discrimination. The government shouldn't be in the business of distinguishing among speech based on content, at least when it's acting as sovereign, when it's controlling what private people do, as opposed to, say, controlling what its employees do or some such, and outside these traditionally recognized exceptions like libel and obscenity and the like. Interestingly, this doctrine of content discrimination being presumptively unconstitutional was long the darling of Justices Brennan and Marshall. And the chief dissenters from it historically had been Justice Rehnquist, very conservative justice, and Justice Stevens, who towards the end of his career was a liberal, but at the time that he wrote these dissents was seen as a moderate conservative. So again, this is a situation where the political valence of these issues, as in a sense in Sons of Confederate Veterans with regard to access to government property for speech, has in considerable measure flipped. So with that I close, and I think we have time for Q&A.
Well, fabulous presentations by everyone. Thank you very much. First, I'm just going to ask amongst the panel, does anyone want to respond to anything that any of your colleagues said? Eugene, I'm wondering if you want to respond to Adam or Adam to Eugene about King versus Burwell in any respect? Or you've just
I try to avoid statutory cases. They're too important.
Okay. Anybody else want to respond to any of your colleagues? Or we're kind of standalone presentations, I think.
Let's open it up.
The next question I just want to ask before we open it up to the audience is, what do your crystal balls say about what are going to be the important cases in this coming term? Anybody want to take a shot at that? Cheryl?
Well, this is a crystal ball that I can actually say I think is a fair prediction since they've already granted cert, so I won't be going way out on a limb. The third iteration of Fisher versus Texas will be before the court again. This is an affirmative action case that has been before the court twice now, and it's coming again. And the question has to do with whether or not the University of Texas' use of race in its admissions policy is fitting within the confines of narrow tailoring. So that one will be coming up. I'm not sure, but I do think that probably, along with Adam, that one of the voting rights cases will come up again. I'm not sure which one, having to do with the voter ID and some of these other restrictions.
They've also accepted cert on a so-called one person, one vote case, correct?
Yes.
Do you want to explain what that's all about? No?
Well, it has to do basically, actually one of the other cases that I hope to talk about was a case involving districting. And it has to do with the question of what happens when the legislatures have to draw district lines. And often this has been said, this is a situation where the voters are not picking the representatives are picking the voters. And so the principles that sort of guide that, the sort of one person, one vote, how do you ensure that you're not packing jurisdictions so as to dilute the voting power of others, this is actually quite crucial. And the case that I didn't get to actually involves a precise issue in Alabama, where the Alabama legislature redrew some district lines and claimed that it was doing so in a way to preserve minority representation, but the caucus, the Democratic caucus, actually said, well, no, actually what you just did was pack in minority voters into the district, and you did so by claiming to follow sort of the letter of the law, but what you've actually done is create a district where you've bleached the adjacent districts. And by that, what is meant is that all of the minority voters concentrated in one, the other district being more white, tending to vote more Republican. It became a way of sort of ensuring Republican political power. So the court in this case this term said that what Alabama did was impermissible for technical reasons. Basically, it said it didn't slice the evidence in the correct way and didn't ask the correct question. But these larger issues regarding districting are going to continue, I think, to come before the court.
Is it likely that there's going to be an important abortion case coming up, particularly out of the Texas abortion statute, abortion clinic statute?
Yeah, so there's a few cases around the country that have involved abortion regulations that purport to promote or protect women's health. And so we draw distinctions between regulations that are meant to protect the fetus versus regulations that are intended to protect women's health. And we know that clinics are closing down as they get regulated. And so there's a question about what kind of review those kinds of regulations should be subjected to. The framework is Casey, undue burden, from the 1992 decision. So does it place an undue burden on a woman's right to an abortion to have these regulations? And the Fifth Circuit actually interpreted Casey as essentially being a kind of rational basis review of these regulations, whereas other circuits have said this is an undue burden, and that what they're starting to do is look at the extent to which the regulations that purport to protect women's health are actually not related to protecting women's health, but are aimed at closing down clinics. And if there's that issue where there's no evidence that they're actually promoting women's health, is that enough to say they don't satisfy the Casey standard? The other issue that everyone's paying attention to is yet another challenge to ACA stuff, which is the challenges by religiously affiliated nonprofits to the current accommodation regime. So what Hobby Lobby got last year was an exemption from the contraceptive coverage requirements in the ACA, and the federal government put out regulations purporting to extend to closely held corporations like Hobby Lobby the kind of religious accommodation that was extended to religiously affiliated nonprofits with objections to the contraceptive coverage requirement. So the religiously affiliated nonprofits had to fill out a form called the Form 700, or after a decision in Wheaton College from last term that was just a preliminary decision, and also the government regulations, there's a notification notifying the government rather than filling out the form, and there's challenges to these forms of accommodation. I think the thing that's really important to keep in mind is that this is an objection to the actual operation of the accommodation mechanism. So government says we're accommodating your religious objections, and here's how you tell us that you have the objection. And the objection is now to that accommodation mechanism, which to my mind puts into question potentially other kinds of accommodation mechanisms. So far, all the circuits have rejected that claim, but there's cert petitions pending.
Okay. Anybody see the possibility of either of the NSA cases getting to the Supreme Court? There was just a district DC Circuit decision. Do you think the court might take any of that stuff, or leave it alone for now?
I don't believe, is there a split in the circuits yet? I'm not sure that I recall there being a split
Well,
in the
there's
circuits.
just a circuit opinion.
Right, so I think it's likely the Supreme Court's going to stay away from that issue for the time being until there's a split in the circuits. But one thing we've learned from watching the Supreme Court over the last few years, you can never really predict what the Supreme Court's going to do. And so the court has certainly not filled its docket for the coming year, and you can be sure that next year at Whither the Court will have a bunch of big cases to talk about.
Right, exactly. All right, let's open it up for questions. If you would just go to the microphone, we'll turn it on. I just want to remind folks that you are being videotaped. We have the university's chief privacy officer with us here tonight, and he reminded to tell you all that if you're going to ask a question, you will be videotaped, so make sure that that's okay. All right, go ahead.
This question might be best for Professor Harris. A portion of the 1L group this summer read Michelle Alexander's The New Jim Crow about the criminal system in the United States. And I wonder if you could comment on the Supreme Court's previous decision, as we read in this book, to grant a lot of discretion to the police force in using racial discrimination when it comes to war on drugs. Do you foresee, in light of the recent, all over the country, all these incidences, do you foresee any of this going before the court, or do you see any changes in this type of authorization? Thank you.
I think, if I understand the question, is whether or not sort of the current political moment suggests that there will be any movement in terms of the court's decisions regarding race and criminal justice. So that's a really interesting question. I guess I would say this with respect to, so the core argument of the book is that, in effect, the war on drugs and its implementation has, in effect, created a generation of minorities, many of them blacks and Latinos, who have been subject to higher and higher and more stringent rates of incarceration as well as sentences, which have, in effect, both disenfranchised and basically created a kind of separate caste. And this racial caste is what Alexander is actually challenging. What's really fascinating about, and I tried to allude to this, is in the court's cases in the race context, is that it has been very rigorous in attending to and the application of strict scrutiny and the use of race, as I said, both in connection with the underlying harm as well as remedies designed to address that harm. So, for example, school desegregation is now subject to the same degree of scrutiny as is school segregation. so both the remedy and the harm are treated the same way. It has been far more reluctant to intervene in the context of the criminal sanction system, and has in fact had a fairly high requirement to prove that race was actually the intentional motivating factor. So in the context of the death penalty, there's been a long history of litigation in which disparities and stark disparities have been attempted to be proven. The court has rejected that. In the context of the war on drugs, there have been efforts to make allegations of selective enforcement, that is, that in fact the ways in which police resources have been allocated and targeted, that certain communities have just, by virtue of that fact, been sort of overrepresented consistently and very starkly. The court has represented that, has affirmed that use. So I think my guess is that there is a very big hill to climb to undo a lot of these precedents. These precedents have been around quite a long time. What I do think is interesting, however, and this, I can't even remember the case that this just recently came up, but I believe it was Justice Kennedy in the context of a case that did not present the precise question of the legality of solitary confinement, actually, in an aside, kind of said that it's time for the court, it's time for us to start actually looking at this practice. Now, why do I say that that's interesting? Because he talked about it in a way that suggested that he was troubled by it. That suggests that there is something, at least I think in terms of the current political conversation regarding the use of the criminal sanction process, what its effects are, and its effects are quite, as Michelle Alexander's books point out, quite deleterious. It basically disenfranchises entire communities because of the felon disenfranchisement that follows. So all of this is to say, I think it's a big hill, but I do think that there are some questions that I think are being raised about this effect, in addition to which we have, of course, Obama's recent initiative to start to grant clemency to some of the people who have been subjected to this over-sanctioning and disparate conduct.
If I could just speak about the broader picture of criminal justice and criminal procedure, I think it's a very interesting area. I think one thing we're seeing is the court, especially in some of its Fourth Amendment cases, is providing some extra Fourth Amendment protection that before, say, in the early 90s and late 80s, it wasn't willing to provide. In many ways, some of the recent Fourth Amendment cases, while not at all uniformly, are more friendly to Fourth Amendment claimants. And I suspect the reason is, what I think many people in the audience may be too young to fully appreciate, is since 1990, the crime rate has plummeted in just remarkably dramatic ways. And ways, incidentally, that I think benefit minority communities, but especially black communities, quite heavily as well, because black communities have long had a much higher crime rate than white communities. That still is the case now, but they had a lot to gain from that decline. And the problem is we don't know why the decline happened. There are a lot of theories. One of them is the decline happened in part because of the severity revolution, because we locked up a lot of people and it was very expensive and was very intrusive on many people's lives, may have been disproportionate in some situations, but it might have taken some people off the street. Now, maybe that's not so, and maybe if we're going to see more clemency and we're going to see more constraints in police power and more constraints on long sentences and such, maybe what will happen is it'll be win-win-win-win. That people who are criminals will still be punished, but punished less. The taxpayers are going to have to pay a lot less for incarcerating them and the like. Communities who really are quite hurt when a lot of their members are locked up will be less hurt, and law-abiding people will be happy because the crime rates won't go up. If it turns out that severity revolution did have something to do with reducing crime rates, and clemency of various sorts, I don't just mean executive clemency, will end up driving the crime rates. Or maybe if what happens is we don't know what caused the decline, but there's something that's going to be going back up because there's some other unknown force that may just happen to coincide with an increase in clemency, then I think you're going to be back to the old system where people were quite understandably, and people of all colors were quite understandably very troubled by the crime rates, and we'll go back to even more draconian system than we had before. And I say this, by the way, as someone who's no fan at all of the war on drugs.
I guess I would just say that one can hold the view that everyone has a right to a community that is safe and still be appalled by the apparatus of the criminal sanction system as it was rolled out because of the disparities in terms of the severity of the offenses and the ways in which people were sort of funneled into those systems at a very early age and never allowed to get out. So we're sort of, obviously, society reacts to the ebbs and flows of these things, and the court is not immune from those ebbs and flows. I think I would just say that what I see now is a kind of actual, even across political affiliations, interrogating the question of the wisdom of the past policies of the last 20 to 30 years.
Okay, great question and great answers. Yes.
Yes, Professor Winkler, assume that you were charged with the duty of writing a brief in which the issue was the construction of either a statutory or constitutional provision which on its face may appear dumb in contrast with the purpose. How would you rationalize what Justice Roberts said in the redistricting case, where he railed against not saying that the people means the same as the legislature, with what he said in the case that you discussed?
Yeah, no, that's a good question. Finding and insisting upon consistency among judicial decisions, even by the same justice, is often a fool's errand. But nonetheless, I think that one might make a distinction in the way that Justice Scalia has generally made a distinction between constitutional interpretation and statutory interpretation. That the role of the court is different in these two different areas. On the one hand, if the court reads a statute and gets it wrong, Congress or the state legislature that passed the statute can step in and revise the statute. Constitutional law often much more difficult for any revision. It's left to the court to interpret them. But that doesn't, I don't think, really explain Chief Justice Roberts' votes in these cases necessarily, because presumably, if that were the case, then the Chief Justice could have said to Congress, well, you've made a mistake in the Affordable Care Act. It was inartfully drafted, and you should redraft it. But I think actually it comes back down to what the Chief Justice views his role on the court is and what the role of a judge is. And I think his view is very different from the view of Justice Scalia. Justice Scalia, who views the court's role as to sort of in some ways police the political branches and to overturn their acts when they're inartfully drawn, to force them to draw them more artfully. Whereas I think Chief Justice Roberts subscribes to an older vision, a more old-fashioned vision of the court's role, one where judges envision themselves as in part there to try to make the law better. When they see a bad situation in the statute that was not intended by Congress necessarily or not clearly envisioned, that they're going to try to sort it out and to try to make the best of a bad situation, rather than taking a bad situation as a reason for the court to strike down the handiwork of the legislature. So I might view that the debate within those larger terms. But it is frustrating to many people who are critics of some of the court's recent decisions when they read a statute that says established by a state to mean established by the state and the federal government. When they read a provision of the Constitution that invests power over electoral rules in the legislature to mean something more than just the legislature, there is a frustration that some feel that the court is unbound by the language that it's interpreting. I don't know if that is an accurate assessment of the court's approach in these cases, but I think that does capture the mood of some critics of the court's decisions in both of these cases, the ACA case and the Arizona election clause case.
Right, the Arizona case actually upheld the commission system similar to what we have in California.
That's right.
So that was very important for us here in California. All right.
Professor Winkler, you said that we can ask questions about another case from the recent term. I had a question about one of the foreign policy cases, the Jerusalem passport case involving, it's called, I have to read this, Civitas versus
Civitas.
Kerry.
Civitas
And
versus
what are your
Kerry.
thoughts, or what are the panel's thoughts on its implications in the future regarding the president's powers over foreign policy vis-a-vis Congress? Thank you.
Curious if others have a different view than me. So the Civitas Ski case was another case, an important case that we talked about whether we would include, but left it out because of lack of time. But Civitas Ski was a case dealing with a dispute between the president and Congress over foreign policy. And in particular was the policy over whether Jerusalem is the capital of Israel. The administration, like all previous administrations, both Democratic and Republican, has taken the position that the administration has no official position on Jerusalem being part of Israel, and is holding off for that to be resolved by negotiations between the Palestinians and the Israelis. Congress, however, passed a law that was intended to force the president's hand by requiring the State Department to put on passports of people who were born in Jerusalem Israel as their country of origin if they so selected. The court ended up siding here with the Obama administration and saying that Congress had effectively overstepped its bounds when it tried to dictate the foreign policy questions here. I don't think the decision was terribly surprising. In fact, I thought it was a case that could easily have been a 9-0 decision, in part because many people on the court who might otherwise be expected to have some lack of comfort with the Obama administration's positions are often among those who have been the strongest proponents for executive power in foreign policy questions. And at the same time, I think that there were other justices who generally thought that this was a delicate question of diplomatic recognition. And that it's one of the very cores of the president's foreign affairs power, which countries to recognize, how to recognize them, how to handle these diplomatic endeavors. And that was the view that ultimately prevailed in the Civitas case.
Anybody else have a point of view on the Civitas case? Eugene? All right, an important separation of powers decision for sure. Pardon? The vote was 5-4.
Was it 5-4? 5-4. Sorry,
I'm
I
pretty sure it's
don't
5-4.
recall offhand.
I think it's one of those split decisions with Kennedy writing the decision. Roberts dissenting. Yes, sir.
So mine is in regards to the EPA decision. Then later this month, you saw Obama do a number of executive actions around climate change. So I was wondering, are those just eventually going to get struck down? Is this kind of a resolving cycle? And once again, how do we factor in, or how is the EPA supposed to factor in environmental regulations and the cost of those when we don't really totally understand the catastrophic costs of global warming and what that might do, taking, for example, like the cost of a Hurricane Sandy, how those things might play out?
This is really not my area, but I guess I would say what's fascinating about this is this, again, the problem that Adam alluded to, which is this question of Chevron agency deference. This is one of the areas where that seems to be pretty much off the table. It's kind of interesting, though, in the Texas case that I discussed, the court actually does invoke Chevron deference. So it's, again, one of those moments where when it seems to support the outcome, it's relevant. When it doesn't, it's not. But I do think you raised an important question because of the problem of requiring the calculation of what may be incalculable. So I mean, that would just be my general observation.
Yeah, I think that's right. And you're certainly right in suspecting that some of the Obama administration's environmental regulations will be coming back before the court. The court has shown a sustained interest in reviewing the Environmental Protection Agency's regulations in this area on environmental matters over the last 5 or 6 years. And so it depends on the particular policies and whether they're going to end up in court, but I would expect to see those cases in court, if not ultimately in the Supreme Court. Certainly those who are opposed to these environmental regulations are among the most well-financed litigants that we have in our system, large companies and power plants and whatnot. And so they can afford the litigation, and so we can expect to see more. I don't think their money makes their litigation that much more successful, but it certainly makes litigation an option for challenging these regulations.
And they have Lawrence Tribe now, so there
That's
you
right,
are.
That's right.
That's right.
On that side. All right, I think we have time for maybe one more question.
Okay, thank you. This goes into the category of contagion or colorful. That when we started the conversation this evening, we discussed a little bit about dissenting opinions and the kind of language that is being used nowadays, language that's most likely inappropriate in the trial court level. My question is this a contagion? Is it really colorful? Is it something that will affect the integrity of the court in its structure?
You know, I think we have to keep it in perspective. Nobody's going out there swearing at each other. Is one bit of perspective. We sort of expect a good deal of gentility from courts, and then when sometimes there's something that's a little less than genteel, we say, "Ooh," but you know, in the grand scheme of things, it's not fighting words. The other thing about the perspective is, you know, you look back on things in the past. Was it, I think, Marshall in one of the cases involving victim impact statements, I think, said power, not reason, is now the currency on this court. You know, people like to turn a phrase. People like to, if they are really angry at something, express it again. As angry things go, most people, when they get angry, say things in an even more colorful way. So I think what we see here is we see something that's been going on for at least several decades on the court, that people end up saying things that are maybe at times kind of strident towards each other, but I don't see that's affecting the bar in any material way. I remember when I was a law student, but when there was less talk about this at the courts, there was plenty of talk about lack of civility among lawyers. It strikes me as unlikely that whatever the justices are saying, whether one wants to condemn it or not, certainly I'm not a big fan of harsh rhetoric in these kinds of situations, is going to have much of an impact anywhere other than possibly in the relations between the justices. One of the things that this kind of rhetoric might make it hard for them to do is for them to work out little kind of compromises on various kinds of opinions. But I don't see lawyers sort of saying, "Ooh, well, if Justice Scalia can do it, I can get away with it too," because we all know judges can get away with things that we can't.
I just, as an aside, I remember a few years ago seeing an interview with Justice Scalia, and he was asked in the interview that if he were king for a day and could make one change by edict in America, what would that change be, he was asked. And he said, "The one thing I would change was the incivility of our public discourse."
So the question is he adding to that?
But again, I think if you look at public discourse, even among politicians, I think we're talking about something that's a considerably higher level. We just view it as uncivil among judges because we expect everyone to be so
Right,
super polite to each other.
As of yet, Justice Scalia hasn't made any comments about Rosie O'Donnell's weight. So it's more civil than what we're seeing in politics these days, perhaps.
Just imagine if we had Donald Trump and Justice Scalia to contend with in the next few years. All right, well, let me thank each and every member of the panel. This has been an incredible program. We've had, the whole program has been videotaped. It's going to be on the law school's website and hopefully uploaded to YouTube so you can watch or take notes on whatever portion you might have missed. So thank you, Eugene, Cheryl, Doug, and Adam, for a fabulous program. There's a very nice reception out on the patio. We kind of missed the dinner hour, so I think we hope to make up for that a little bit with our reception, and we look forward to seeing you out there. Thanks so much.